read your opening statement yet, so I may have some further questions, but if I can commence with APRA's role in the First Guardian Shield issue. I understand your main role is as the regulator of the trustees and their platforms, and that ASIC has taken the lead in coordinating a regulatory response in large part. But I also note that Diversa was a for-profit trustee and had both First Guardian and Shield products available to its members via its platforms. I also understand that Diversa is not a stranger to APRA in terms of regulatory matters. So can I just take you through a little of the documentation I have, and perhaps we can get to your role with regard. So the first item I'd like you to have a look at is a statement from APRA, a media release from from January 2023. Chair, and I've got multiple copies here. Are you familiar with that, or would you like to wait till you have it in front of you?
Well, I'm sure we will be familiar. I'll ask Ms. Cole.
Not in recent history.
Thank you,
Senator. So
it would be handy to have it in front of us.
It's coming to you now.
Could I say something just in relation to what you said already, Senator?
Yes.
I think it's not quite correct to say that ASIC are leading the regulatory response so much as ASIC are leading the enforcement response.
Okay,
we have our own regulatory response, but ASIC are taking the lead on what I'll call the formal enforcement action.
Thank you. So you have that document in front of you now, is that correct?
Yes.
Okay, so if I could just draw your attention to a couple of elements in there. You announced on the 24th of January 23 that you were imposing additional licence conditions on Diversa trustees. What were the major concerns of APRA at that time with regard to this entity?
Well, without going back into this, I'm afraid I can't tell you off the top of my head now in relation to this specifically, other than if it's reflected in here, Senator.
Well, I think it's reflected in the press release, Senator, particularly in the first 3 dot points that summarise our concerns at the time.
So can I just ask a couple of questions about the second set of 3 dot points? Governance and risk frameworks with a particular focus on third-party service providers. Who were those third-party service providers?
I think we'll
check if we know.
I think we'll have to take that on notice.
And what services were they providing to Diversa?
Sure. At this distance from these events, Senator, I can't really add anything expanding on what is in this, but we will take that on notice.
Okay. You noticed persistently high fees, and you mentioned that in your second dot point, but then you asked for the conduct of an independent review to ensure APRA's concerns had been adequately addressed. By whom was the independent review undertaken?
Again, I'd have to get you that.
And to what standard was it required to adhere?
I'd have to get you that on notice.
And when was it received?
I'd have to get all of that information on notice.
And can you provide that in a timeline, whether that was before or after the listing of First Guardian and Shield?
Can we tell you whether we got it before then? I'm sure we will be able to when I've been able to go back through.
Okay.
There's somewhat historic information.
So if I can just say from a layman's point of view, you had a look under the hood at Diversa and you found some pretty significant problems. So can I ask then, having had the opportunity to pull up Diversa and impose additional licence conditions, did you have any concerns at this point about the products that Diversa was making available on its platform?
Well, I don't. What we will have done, and what is typical for us to do in this sort of context, Senator, is to obtain the report and to conduct supervision by reference to any of the issues in that report. But as I can't...
And the report you're referring to there, is that the independent review that I've asked you?
Yes, exactly. Sorry, that's what I mean, the independent review report, we will probably call it. And supervise, add additional supervision, scrutiny on areas that we were not satisfied, well, that the independent reviewer highlighted. But I'm very sorry, but at this distance I can't remember the specifics about that. I think we could probably offer some thoughts on fee levels, because those would be things that would be highlighted in the annual performance test and our own collections of information.
And you've indicated that in that second dot point there.
Yes,
but I am really interested in what the independent review was asked to cover off. And seeing as they were in your purview, my question is, can you tell me if you had a good enough look to observe what the trustees were doing with regard to putting products on their platform?
So, Senator, as we said, this press release almost is 3 years old, so we do want to come back with information. We'll take that on notice. The general proposition, though, around governance on trustees and platforms has been an issue we have been looking at for some time. And I might...
As far back as 2023?
So we certainly, in our last 2 corporate plans, we have indicated investment governance, including platforms, is an issue that we want to have a close look at and have been having a close look at. So
that would cover off the years 23 and 24.
23 and 24.
And this document is about 23, and at that point of time you were already looking at the governance of platforms.
We were looking at investment, so we've been looking at investment governance for many years, including liquidity arrangements, including valuations, and certainly more recently on platforms. But I will just ask if we can talk about how
I think your last appearance on the 9th of October, you indicated reviewing the investment governance of major platform providers as part of that ongoing work.
Yes, but that started at an earlier phase. Perhaps Ms Beverley Smith will outline what we've been doing over what time period.
Sure. Thanks, Senator. Carmen Beverley Smith, the Executive Director of Superannuation, Life Insurance and Private Health Insurance. So specific to your question, subsequent to the last hearing, we have completed the review that we indicated that we were in the process of doing on the major platform providers. Those major platform providers comprise approximately 95% of all member assets that are distributed via platforms in superannuation.
I might come to that a little later, because that's kind of the current situation.
Yes.
I just want to interrogate Diversa if I can, seeing as they're so significant for so many Australians who really, they've lost their future. They've not just lost money, they've lost their future. And that has a very significant impact. I've got another document I'd like to table, if I can, from the Secretariat's, with the Secretariat's support. This is an article with you, Mr. Lonsdale. Sorry, just before I jump on, can I confirm that you are taking on notice what actions APRA took in response to any concerns that became evident to you about Diversa?
Yes, we're taking that on notice.
So you're going to have a look at that. Thank you. So this document that I've just provided you is a document from August 21 of this year, when the full scale of what's been going on with First Guardian Shield was pretty well known. You're quoted in this article on the website Professional Planner, Mr. Lonsdale, saying it's primarily ASIC that's looking into the issues of these products on the platforms, and you're quoted in here as saying on the second page, we flagged when we did the performance test review in 2023 that we had some concerns with platforms, which is why I was asking you about being aware of Diversa, putting in a licence conditions on them in 2023, and this statement that in 2023 you already had some concerns with platforms. Are you sure you can't recall if you had any concerns about Diversa in 2023, seeing as you're already in there looking at them and sanctioning them with additional licence conditions?
Senator, as we took on notice, the Diversa measures that you flag in the press release, they are 3 years old. We want to come back with the most accurate information that we can because it is a very significant issue. We've taken that on notice and very happy to do that. Our investment governance work, which includes our platforms work, as indicated, we have been looking at for quite a while. We have talked about
Since 2023 or prior to that?
Well, so what have we been doing in 2023? We have revised our investment governance rules in 2023. We undertook a thematic review on unlisted assets, particularly on liquidity in 2023, and we published that in 2024. When we became aware of specific concerns with Shield at the end of 2023, particularly on MIML, we commissioned an independent report. And through 24-25, there's been a lot of work happening with our co-regulator ASIC and supporting them on various issues related to Shield and First Guardian. And at the end of 24, we began scoping our work on the thematic review on platforms, which we delivered, I think, publicly in October 25, Senator. So there's a long history of APRA working on investment governance, including platforms.
And if I can take you to the 2023 Superannuation Performance Review and the media statement accompanying that review, which is the third item that I'm going now to provide to the Chair and ask you to distribute from the Secretariat, if I can, thanks. You released the results of the 2023 Superannuation Performance Test. And there's an important quote in there from Ms Cole towards the end of that document where she says, members in trustee-directed products make active decisions about their investment options and might select products, and some might select products for reasons beyond performance. Nevertheless, all trustees must take responsibility for the products they make available and ensure the products they offer are in the members' best financial interests. Right, so I read that as meaning APRA was concerned as far back as August 2023 about the appropriateness or the quality of the products being offered to members for these for-profit retail platforms. There's another quote in there that says trustees with multiple failed products had rationalisation programs underway. What action was APRA taking against these trustees in 2023 to ensure that they actually were offering products that were in members' best financial interests? And where was Diversa in your observation?
Well, we were doing several things, Senator. We have observed since I think this was the first year that choice products were considered in the performance test, because the first couple of years the performance tests were My Super products only. So having been given the regulations that meant we could expand the performance test, we ran the performance test, which at a highlights level did raise concerns that the trustee-directed products in the choice sector were not generally as well performing as the My Super products. So, as we had done with previous iterations of the performance test, we in our supervisory interactions sought to get the trustees to focus on how they were going to move their members to better products or better funds. That is a much more complex job than it is in relation to My Super, because members have typically gone in there with financial advice and have considerations such as tax considerations. So we were certainly have been pushing trustees who do not show as well on the performance test outcomes to encourage members to move to different products.
I'm sure you were pushing.
We can't order that, but nor can we. We can't direct that members should be automatically moved in circumstances where members have chosen to go there and may have considerations other than performance because they've got tax issues or they've made choices for particular reasons.
Members in the First Guardian and Trust were hardly choosing transparently. They were very grossly manipulated by a large number of people in the whole food chain who were doing the wrong thing.
Yes, we were clearly not aware of that, Senator.
But you had Diversa in your sites in 2023. You had imposed on them additional licence conditions. If you were looking at Diversa in 2023 and you were acknowledging in August 2023 that there were trustees with multiple failed products, why were you not investigating Diversa?
Well, Senator, I can't tell you again until we've had a look what was in that report. It looks from the dot points that it concerned risk management issues and may have concerned performance test issues. I simply can't tell you at this point. What I can tell you is that we were not aware of issues concerning First Guardian or any of the funds that First Guardian or any of the trustees that First Guardian were associated with or their trustees until a much later date.
So I have further questions, Chair. So
I'm going to have to rotate the
Thank
call. Senator Sharma.
Thank you. I just wanted to follow my colleague Senator O'Neill's line of questioning about First Guardian and Shield. I'm relatively new to this though, so just forgive the simple questions to begin with. But what were the superannuation trustees that made these products available on their platforms? It's Macquarie, Netwealth, Diversa and Equity trustees, is that?
So Macquarie was Shield,
Yep.
Equity Trustees was Shield, Diversa, Netwealth and Equity were First Guardian, Senator.
Okay. And then of the 12,000 Australians who've been impacted by this, what was the quantum that would have invested via these platforms? What's the overall cohort?
1.2 billion, my colleague is telling me.
Sorry, Senator, could I ask you to clarify the question?
Oh yeah, so I understand there's about 12,000 Australians who've incurred losses as a result of this, and the figure was 1.2 billion. How much of that, both individuals but also dollar terms, is attributable to people who've invested via these 4 superannuation trustees?
As I understand it, Senator, it is the entirety of the 1.2 billion.
Everyone's gone in for these. Okay.
So
There's no other way they could have invested in Shield.
as I understand it, Shield and First Guardian products were only offered on platforms in funds under the trusteeship of those 4 trustees we mentioned.
Okay.
I'd like to be able to take that away and double check it, Senator. Sorry, I had understood that it wasn't all super monies, but I think we better just check.
Not all super monies, but the 1.2. It was only those 4 trustees, as I understand it, that offered those products on platforms for superannuation members.
Yeah, sorry, I'm just asking, as I said, forgive the rather simple questions, but could an Australian have invested in Shield or First Guardian outside these 4 superannuation trustee platforms?
I think I'll have to take that one on notice, Senator. I'm not sure, but through the superannuation system, the answer is yes. I don't know if outside the superannuation system whether there's a different answer.
Okay. I mean, I know that wouldn't be your responsibility then, I guess. That's correct, right? Okay. And when you wrote to, so I believe you wrote to all superannuation trustees on the 7th of October 2025. I was just looking at that letter on your website earlier. And I believe somewhere in there you said if certain steps were not taken, robust regulatory action and the full use of APRA's regulatory tools would be used. What does that consist of, robust regulatory action and the full use of APRA's regulatory tools?
It consists of being able to impose licence conditions and or directions.
Okay, and have you had cause to employ any of those today?
Senator, we are in
with respect to this?
We are in a process at the moment which well, maybe I'll ask my legal counsel to explain what we can and can't say about this process at the moment.
Yeah, so the range of APRA's enforcement tools are set out in our enforcement approach. In this sort of circumstances, not talking specifically, my colleague Ms Cole is right to suggest that licence conditions directions to require them to perform an uplift programme or something that will commission further independent reports and so on are tools in our toolkit.
Sorry, I couldn't quite hear what you were saying there, Mr. Calverley.
Yes.
Yeah, so what are your directions? Capacities?
So in high level terms, so if we think an entity is in breach of its regulatory requirements, we can direct them to do something or to restrain them from doing something. But what I think we should say is that our position is that we generally don't make administrative actions public until we've concluded the procedural fairness requirements of utilising that toolkit that we just talked about.
Okay, and sorry, the status of the consideration of the use of those powers, what are you able to advise me?
I think there was a clue there in what my colleague said.
I must have missed the subtlety.
We are
I'm
obliged
sorry.
to give procedural fairness requirements to entities where we are considering imposing directions or conditions.
That includes...
And until that procedural fairness process concludes, we're not in a position to make any further announcements or disclosures.
Okay, and procedural fairness would normally entail a right to hear and contest the accusation and provide evidence in response?
To understand the matters that we're putting to an entity and to allow that entity to put forward its own position in respect of that evidence and what we were proposing.
Okay, okay.
Senator Sharma, can I just ask if they're acting with ASIC in this? Are you coordinating with ASIC in taking your action? Because you talk about being cousins.
So at the beginning, Senator, when I said I just wanted to make a distinction between regulatory action more generally and formal enforcement action through a court process, that was exactly really the point I was going to, which is that we have a set of tools, ASIC have a set of tools and ways of doing things, and we're highly coordinated in how we are approaching the use of our tools.
Highly coordinated, thank you. Thank you, Senator Sharma.
That's okay, Senator Randall. Was APRA rather given any warning about First Guardian or Shield before ASIC took action?
Senator, I don't think so, but let me just check the dates. So the first time we knew something about Shield was December 2023, and we had prompt discussions with Macquarie Investment Management Limited at that point, and shortly afterwards with ASIC. So I think the answer in substance to your question is no. And it was a later point in 2024 when we knew about First Guardian.
And when you first knew about First Guardian, what steps did you take at that time? So you said when you learnt of Shield in December 2023, you had discussions with Macquarie.
Yes, we required Macquarie to do to obtain a third-party independent report on their systems and processes in relation to First Guardian.
Sorry, when was that, Ms Cole?
Sorry,
when?
The Macquarie report.
The request from Macquarie.
The request to Macquarie was April 24. We had numerous discussions with ASIC about the approach to that. And then when we became aware of the First Guardian matter, it originally appeared through discussions with ASIC that First Guardian were carrying out a capital restructure. So there was not immediate clarity on what was happening there. And we then again liaised with ASIC, who we agreed would again be in the lead on enforcement action in relation to First Guardian.
And now, so what time of year was this? This is in...
That is... I believe that takes us through to December 24, when ASIC informed us of certain investigations that it was undertaking. All of this period was subject to a lot of discussion as to who was doing what and ways to coordinate.
Yep. So you mentioned that First Guardian first came onto your radar because of a capital restructure. Was that in December 2024 or was that earlier?
No, sorry, Senator. December 24 was when we knew more about the action that ASIC was taking. In relation to May 24, that's when we first became aware from ASIC of various issues on First Guardian, which at that moment appeared to be a capital restructure issue.
Okay. And when ASIC issued the Section 912C notice to Macquarie regarding the concerns about Shield, when was APRA informed of that?
Not sure I know the answer to that one, Senator.
Did you know in advance or did you only...
I don't believe so. Can you tell me what it was again? Just so.
Yeah, the issuing by ASIC of a Section 912C notice to Macquarie regarding...
Do you remember, colleagues, what the 921C notice was? I might have to take that on notice.
Okay.
Senator.
I believe it's a formal warning to Macquarie. I might be mislabelling what a Section 912C notice is. Is that what you understand it is?
I can't think what a 912C is at the moment. It's an ASIC process and I can't just think what it is, but we'll take that on notice.
Okay.
But Ms Cole, you keep saying that you're, joined at the hip to your cousin entity, ASIC. You're saying we were coordinating about who was doing what. You've used the term highly coordinated interaction with them. Yet, from what you're saying, there's gaping holes in your communication with ASIC, and there's certainly no indication that although you had the warning about Diversa, you were looking under the hood at what they were offering on their platform.
I don't accept that there were gaping holes, I'm afraid, Senator. I think we were, I wouldn't say joined at the hip, I don't like that expression really, but we were highly coordinated and we continue to be highly coordinated. It's just that we clearly do have different mandates in the Twin Peaks system. We have a mandate that focuses on the system and the prudential level, and ASIC have the lead on consumer protection issues. That is the way the split happens, and when something like this happens where there is dual regulation with us looking at different aspects of what entities do, we have that level of coordination.
You're further up the food chain. You get the early warning. You get to see under the hood of all of these entities and see what's going on. You're already into Diversa. You're already looking at them. You're already in 2023 talking about the platforms as an area of concern. You've got Diversa in your sights and you can't even remember anything about it and you didn't do anything about it. Did you talk to ASIC about that?
I can't tell you at this moment because it's 3 years ago.
Senator, I don't accept the characterisation. We're going to come back on Diversa. We will have quite a bit of information on Diversa because that was a case where we actually took action with licence conditions, so we'll be able to talk to you about exactly what was behind that and what happened. I think it's important to note, when you say an early warning, we are a prudential regulator, so I think it is true to say that we're at the front.
Yes.
But we examine things from a system point of view. So we are not, there are thousands of products on platforms, literally thousands of products. We are not examining the thousands of products. What we are doing is looking at the system. We're designing rules to ensure that trustees exercise due skill and care, they act in the best financial interests of members, and they have due diligence in developing, and this is important, offering and reviewing investment options. And we do that by having high-level rules that we apply at the governance level.
Yep.
And so what we're saying is that we thought that there were particular issues, not with these particular products that you're talking about, but general governance issues, and we've spent quite a bit of time drilling into that. Now, it was ASIC, as the responsible regulator looking after serious consumer harm, MISs and financial planners, who became aware of these particular issues before us.
Yeah, I've got more questions. You go. Sorry. Senator Sharma, thanks for letting me clarify.
Clarify. That's an understatement. That's quite all right, Senator. Now, so when did APRA first become aware that Macquarie had been formally warned by ASIC?
Well, from what I have here, which I can expand on notice, is we had conversations with ASIC and Macquarie in December 23. Now, of course, I'll take it away and go back and see whether we knew of the particular notice being served that you've referred to, Senator.
Okay. And once you became aware of that conversation, did APRA take any steps to liaise with other APRA-regulated trustees who were offering that product, Shield?
I think I might have to take that on notice as well, Senator.
No
The only other one was equity trustees.
Equity trustees, I thought, yeah.
And NetWealth? And NetWealth.
NetWealth was First Guardian, Senator. We're talking about Shield now for MIML.
So do you recall if APRA proactively engaged with equity?
Oh, hang on.
Trustees?
My colleague is pointing out that we did. Yes. We engaged with MIML and equity trustees regarding the issue, including member communications, in April 24.
In April 24 with equity trustees, okay. And when ASIC reached the agreement for an enforceable undertaking with Macquarie, was APRA consulted on that?
We were certainly made aware of it and the discussions in advance and the direction of travel this was taking.
And was APRA supportive of that? I guess I'm asking, did you have any concerns about the moral hazard that's potentially created here by the decision to go lightly on Macquarie?
Look, I think the primary issue for ASIC, and which we would all be very concerned about, it was arriving at a conclusion that would enable the members there to be made whole at the earliest possible time to relieve the stress on them. But the decision making there was ASIC's, and we were aware, as I say, of the direction of travel.
Okay. Last question. The Assistant Treasurer has suggested that superannuation funds could be asked to contribute to the compensation scheme of last resort through a special levy. Does APRA have a view, or has APRA offered a view on the implications for APRA-regulated super funds being levied in this way?
I don't believe we have given any advice on that subject, Senator.
What is your view on it?
I think it's...
Well, we don't give views on that,
No,
Senator.
they're not here to give an opinion.
Our view on 23 is that if exercised, we provide the government with advice, and that is it. So there's an administrative function for us to do.
Have you been asked to provide advice on this issue?
On Part 23 we have, Senator.
Yes.
Not on the compensation scheme of last resort.
Only on Part 23.
Just to clarify that.
And that's not the formal advice required under statute. It's just consultation with Treasury and the Minister.
Okay. And that's on Part 23, not the compensation
Yes,
scheme.
just to clarify that distinction, there's the Part 23 power, then there's the compensation scheme of last resort, which your question referred to.
Yep.
We have not been asked to give any formal advice, or any advice on or view on the compensation scheme of last resort. And in relation to Part 23, it's in the public domain that NetWealth have
written to the Assistant Treasurer.
Yes. And we have not yet given the formal advice that is required.
To the Assistant Treasurer to inform his response?
Correct, because there would be certain steps and procedures that will have to be gone through and information gathering before we will get to the point of being able to give her formal advice.
Okay. Thank you. That was all I had, Chair.
Thanks, Senator. My ambition to get to ASIC before the dinner break I don't think is going to be realised.